Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn. Welcome to our episode on fiduciary duties. Before we get started, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. All right, so let's tackle this topic key concept style. The first key concept is the definition of fiduciary duty. Black's Law Dictionary defines it as follows: when one party must act for another, they are entrusted with the care of property or funds. Okay, that is not particularly helpful because it's too vague, but we can clear this up with the rest of our key concepts. The second key concept is that fiduciary duties are not limited to financial matters. Fiduciary duties are much broader than that and vary based on the parties involved and the context. In general, fiduciary duties will exist in situations where one person gives another special trust or confidence to another person to help them. The third key concept is a list of non-exhaustive examples of relationships where fiduciary duties exist. In the corporate context, directors of corporations owe fiduciary duties to the corporation and the shareholders of the corporation. Members of an LLC owe fiduciary duties to the company and the other members. Partners in a general partnership owe fiduciary duties to each other too. In a testamentary context, executors and personal representatives of estates owe fiduciary duties to the beneficiaries and heirs of those estates, and a trustee owes fiduciary duties to the beneficiary of the trust. In a professional context, lawyers owe fiduciary duties to their clients and doctors to their patients. In an employment context, employees owe fiduciary duties to their employer, and agents in a principal-agent relationship owe fiduciary duties to their principals. The fourth key concept is the standard of care. Those that owe fiduciary duties must discharge them with a certain standard of care. Generally, they cannot be negligent in discharging these duties. There are some contexts where the standard can be modified to gross negligence, willful misconduct, or some other standard. But for purposes of our discussion here, we're going to stick with the negligence standard. The fifth key concept is examples of fiduciary duties. Again, this is non-exhaustive list. They are just examples. In the corporate context, directors, members, and partners all have similar duties. A duty of care and a duty of loyalty, to be more specific. For a duty of care, that means when making decisions, you must do a certain level of due diligence to ensure you are not negligent in your decision making. For the duty of loyalty, that means things like you cannot compete with your employer or take corporate opportunities for your own benefit. In the professional context, lawyers have a myriad of fiduciary duties to their clients, but a few examples are a duty to be diligent and timely, duty to communicate, duty of confidentiality, and a duty not to engage in conflicts of interest. In the employment context, employees have a duty of loyalty, which means, among other things, the employee has a duty not to compete with the employer, not misappropriate the employer's trade secrets, a duty to account for profits to the employer, and to disclose conflicts of interest to the employer. I hope you have found this episode on fiduciary duties helpful. Again, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. With that said, thanks for watching, and I'll see you next time.